Okay, I'm reading from the Reference Guide to Regulatory Compliance. I am inside of a section IRS Rules and Regulation. I just happen to be in subpart B or 2. This is reporting that has to be done to the IRS by the bank on foreclosed or abandoned property. It's from the Internal Revenue Code, Section 1.6050J. The purpose of this reporting is to verify the borrower's gain associated with property that is abandoned or upon which the lender forecloses a mortgage or security interest. This covers the lender, and the lender is any of the following 6 things. Any person who, in connection with a trade or business, lends money or on secured property. A person does not have to be in the business of lending money, and for example, that is any equipment dealer who provides financing for the purchase of equipment incident to the sale is covered even though the dealer is not in the business of lending money. Third, the lender in pools of fixed investment trusts and similar arrangements, the trustee, record owner, or similar person is considered to be the lender. And in corporate, tax-exempt, and other bond issues, a trustee on the issue is considered to be the lender. And in governmental units, the trustee is considered to be the lender. A subsequent holder of a loan becomes a lender and is responsible for events occurring while the loan is in his or her ownership. Property covered under the foreclosed or abandoned property reporting requirement is it includes all property, both real and personal, except for tangible personal property held for consumer use, which is personal property covered only if it is held for commercial purposes. So only commercial purpose property is able to be considered under this reporting, but not personal property if it's for consumer use. Way to make that complicated. B, property held for more than one use is subject to reporting requirement. And C, reporting requirement covers real property used as a residence, even though that's consumer purpose, but it's real property and not personal property. So, interest acquired in property is on the earlier of the date title is transferred to the lender, or date possession and burden of benefit of ownership are transferred to the lender. If a borrower has a right under state law to object to lender's acquisition, then the interest will not be acquired until the objection period is over. Which, let's say that for the 3 years after a property is foreclosed upon, the person that was foreclosed upon has the right to recover the property. Then the bank doesn't have to perform the IRS reporting until after that period under state law. C, the property acquired at foreclosure sale, lender's acquisition occurs on the later of the day of the sale or the date any right to redeem the property expires, as I explained in the example prior. D, the lender's acquisition of an interest in property for a limited purpose, such as completing improvements on the property, is not covered. That's very interesting. I think that might have to do with property being used as security for improvements. If it's like a temporary improvement loan. I haven't really seen those products existing, so I can't speak too much on that. But E, property covered is E in the coverage section refers to the interest, the date the interest acquired in property. And that's E, to better explain, is if lender acquires an interest in a partnership, trust, or other entity in satisfaction of a loan secured by entity's property, then an interest is acquired in the property. Well, I guess we're just explaining that a lender is acquiring interest in a partnership, trust, or other entity to satisfy a loan secured by that property. Then the interest is acquired and is covered under this section. Reporting when is required is I, when the lender acquires a property at foreclosure. Roman numeral 2, when the lender retains property in satisfaction of debt. 3, when the lender takes a deed in lieu of foreclosure. And 4th, when a third party purchases the property at foreclosure if the proceeds are applied to the borrower's debt. That probably should have been listed first in the coverage section so that we understand what they mean by interest in property. Nevertheless, it is not covered for meaning that the bank doesn't have to perform IRS reporting if the property is owned by foreign borrowers and the property is outside of the U.S. and the lender has received a W-8 from the borrower. Section C about abandonment. This occurs when facts and circumstances indicate the borrower intended to and has permanently discarded the property and the lender has reason to know of the abandonment. The lender will be deemed to know the property is abandoned if the lender should have known through reasonable inquiry that the borrower abandoned the property. Abandonment must be reported if the lender knows of abandonment and does not commence foreclosure proceedings within 3 months, and the lender's interest is impaired or terminated through a foreclosure sale with no proceeds applied to the loan, or if the lender knows or has reason to know the property has been abandoned. The reporting requirements by the bank to the IRS involve a Form 1099-A. This must be filed by February 28th of the year following the calendar year the property is foreclosed or abandoned, and it can be done by March 31st if it's filing electronically. The contents of foreclosed property, I don't understand why it says that. The contents of the Form 1099-A is going to be the name and address of the borrower, the borrower's TIN, the general description of the property, including the address of if it's a real property, and whether the borrower is personally liable for the repayment of the debt. The date on which the lender acquired the interest in the property shall be reported on the 1099-A, as well as the amount of the principal outstanding at the time of the property was acquired by the lender. If the borrower is personally liable for the debt, the fair market value of the property at the time the interest is required, the amount of debt satisfied by the acquisition of property, and any other information required on the form. The list of contents of abandoned property includes name and address of borrower, borrower's TIN, whether the borrower is personally liable for the debt, and the general description of the property, including the address of the real property. The date on which the lender first knew or had reason to know that the property was abandoned has to be included on the 1099-A, as well as the amount of principal outstanding on the date of the abandonment, and if the borrower is personally liable for the debt, the fair market value of the property at the time of abandonment, and any other information required on the form. If there are multiple borrowers, the bank must file on each, unless the property is community property or held as tenants by the entirety. Each acquisition or abandonment must be reported separately unless there is only one loan. The statement to the borrower must be provided by the bank no later than January 31st of the year following the calendar year the property is foreclosed or abandoned. The contents of the statement must include the name and address of the person making the return, the name and address of the governmental agency or unit, if it's applicable, the information reported to the IRS on IRS Form 1099-A, and a statement that the information is being reported to the IRS. This may include a copy of the 1099-A along with the other required information. Relationship to discharge debt reporting. For foreclosures and abandonments that are reported on Form 1099-A, discharges must be reported on Form 1099-C, and if within the same calendar year a debt is discharged in connection with a foreclosure or abandonment of secured property, and both forms would be required. Only a Form 1099-C is required. Okay, so we're making this, in other words, the 1099-A is supposed to be used for foreclosures and abandonments, and the 1099-C is supposed to be used for discharges, and the bank should know the difference. But if there is a discharge in connection with a foreclosure or abandonment within the same year, only a Form 1099-C is required. But I would check on that because that's completely, confusing. I mean, it says right here, if within the same calendar year, a debt is discharged in connection with a foreclosure or abandonment of secured property, and both forms would be required, only Form 1099-C is required. So I guess what I'm trying to say is that if there's a discharge in connection with abandonment or foreclosure, you really only need to file a 1099-C as the bank. The penalties here for failure to file information return is going to be $100 per return, with a maximum of $1.5 million in a calendar year, unless it's intentional, in which case it's $250 per return with no annual max. However, if we correct this by filing the information within 30 days, the penalty is only $30 per return, and there's a maximum of $250,000 annually. If it's not corrected within 30 days, but it is corrected by August 1st, then the penalty per return is only $60, and there's a $500,000 maximum per year. However, there will be a de minimis exception if the failure to file is corrected by August 1st and the failures to file include less than 0.5% of total returns filed. But if your bank didn't do it altogether, then it's going to have to pay. If it missed one and it performs 100, 200, I would say, then you might get the de minimis exception. But likely, if you're going to fail to file something, you're probably going to fail to file them all. Failure to furnish statement to payer. $50 penalty per return and $100,000 max per year, unless it's intentional, whereby it's $250 per return with no maximum. The failure to provide TIN on reports is going to be a $50 penalty per return, up to $250,000 per year, or $100,000 for taxpayer with average gross receipts if not more than $5 million. But if it's intentional, there's going to be a penalty of $100 per return that doesn't include the TIN, and there'll be no maximum for the year. I think I'm going to break before going into backup withholding that has to be reported to the IRS, just because I have one more minute left.